Live streaming, so you're good to go.
I didn't see how you do it.
So yep, your live stream. I was trying to use Internet Explorer, and Internet Explorer doesn't like things.
Oh,
I had to
so you had
reset
it.
it. I just moved to
Okay,
default.
that's because I followed that.
Yeah, and it hijacked me. It wasn't
I
your
wouldn't
fault.
know how to fix
Right.
that. So, you can see that. Should be- Say yes to everything. I never got
Unmute. So that way, if this person's talking, people on Zoom can hear, and on YouTube, and then you want speakers muted down here. So this is set up perfectly just as is. So, and let's see, does this show me?
Let's see if I'm on the right place. I've never been here before. Is there changes or changes? Okay.
You're on site, and there you go. I'll make sure to get it started. Should be, it's not gonna be a lot.
the word, yeah, it's, you know,
Yeah, we're
it's,
set. We're all good to go. It's live
Oh,
streaming.
I want to be able to tell whoever, how do I go in?
So you can, if they want to watch it on YouTube, they can just go to YouTube and search for Thurston County Superior Court. And then it'll be live streaming under there. There'll be it'll just come up as.
That's all I have to do?
Yeah, just go on the YouTube and search Thurston County Superior Court.
This is the only one on YouTube?
Yeah, it's the only one live streaming today. Yep.
Okay.
You're welcome. Right, so you don't have like your everybody needs to.
well, let's see, it's everything that's clicks on this. Where you from, because that's all is actually.
Yeah. Oh, yeah. Well,
It's everything. There's
Everything's working here, right? There's see what's our problems.
since we're not happy for him, let's get you connected here.
Assuming it'll be fine since it was fine yesterday.
Yeah, I don't see why it wouldn't. There you are. Next, finish.
Patience. Okay.
There you are.
Jane, look
the district court space. We saw him. We saw him. Yeah, he poked his head in just when he walked in the building. Okay, we'll do. Yep, bye. Joey, do you know where that door goes?
So it goes up to the district court chambers area. So there's kind of like the one for Superior Court on the other side. There's an area similar to that with chambers and space for clerks and whatever.
Okay, I think I'll just go this way then. I'm trying to find the judge.
He's probably up in the Superior Court chambers.
Yes.
Well, wait, I hear someone coming through the doors over here, right?
Think you can come down there?
I wonder if Steve found him.
You're going.
Yeah.
Yeah, there's definitely.
So there's.
Providing a message from Christine, and it says we have the spirit.
All rise. Superior Court for the state of Washington is now in session. The Honorable James J. Dixon presiding.
Thank you. Please be seated. Good morning, everyone. Do you have anything with a pleading? You have any pleading? That's all I need. Yep. Thank you, Steve. The matter before the court is Lisa Steele et al. Versus Olympia Early Learning Center et al. 11-200-995-2. This matter comes before the court this morning for reasonableness hearing, continuance thereof. When we were last in court, Mr. Bolasina, the witness, was testifying on direct examination. Is the witness available? Mr. Bolasina, good morning. If you'd be kind enough to approach the witness stand, the court will administer the oath. Do you swear or affirm the testimony you are about to provide is true and accurate to the best of your knowledge? I do. Thank you. Welcome again. Please have a seat in the witness chair. Mr. Cochran, good morning to you. And you may continue direct examination of the witness.
Remind me of protocols. We take mask off?
We don't.
All right, great. Thank you. Mr. Bolasina, I'm going to record permission to republish the Chaucer Blunter package, which you're not responsible for answering on, but I did want to just revisit these to recontextualize ourselves. We spent a fair amount of time in your testimony the last time that you were here talking about some of the early investigation that you did into both the plaintiff's theory of the case and the defense theory of the case. Do you remember that?
I do.
In particular, we talked about some of the interview notes of Olympia Early Learning Center employees that you had interviewed and administrators there as well, right?
I recall that, yes.
All right. And so you just to kind of give us again a time frame, my memory is he came and started in as the attorney for the Olympia Early Learning Center in May of 2011. Is that right?
Yes.
And then that stretched all the way to the point basically that Rose Hordahl signed off on consent judgments in late October of 2012. Is that square with your memory as well?
I thought it was late September of 2012, but I might be incorrect.
This is a little problematic. Is the microphone working in there?
There you go. Wait, oh, press it again. Green means you're muted.
Green means what?
Green means you're muted. So.
Oh, okay. Then
Are you able to hear that, Ray?
Yeah, I did.
Okay.
I'll pull it closer to me.
Fumbled when you said the year.
If you could just start over again. Your answer. The question was, does that score with your memory?
My memory is late September of 2012. But that, I mean, there would be a signed document that would confirm or contradict that.
There it is, and it's Exhibit 105, and I would be happy to.
They're on their way. The exhibits are being transported as I speak.
Well, see, now, with the court commission, I'll hand you volume 1 and volume 2 of the exhibits. Volume 3, actually.
Should I take a look?
Yeah, if you would. Volume 3 is going to have parts of 105. Well, see, if you would, if you can identify the exhibit that we are looking at in 105.
This appears to be the settlement agreement and release for Amanda Wyrick. And on one side, and Olympia Early Learning Center, Steve Olson and Rose Hogarth on the other.
All right, in the specific page that I wanted us to look at on this one, we are all published it with court permission.
Granted.
Which is page 5. I just wanted to help establish the time frame in which we've been working. And does this show here that we're going to finally signed off on using it October 22nd?
It does.
2012. Okay, so that's our time frame. So in the fall of 2011, we spent a lot of time looking at notes. I want us to turn to Exhibit 74, and I should go see that. I can find it too.
Oh, thank you.
Finder you up here.
I have exhibit 74.
All right, and if you would, can you identify what the document is?
This is a letter from you to me dated October 21st, 2011.
Right now. Should I ask that you wonder?
No.
Both. Is it okay if I, should I ask you each time, or is it okay if I publish it?
Parties have standing permission from the court to publish exhibits as they deem appropriate.
Thank you. Mr. Bolstein, just look at the time frame, October 21 of 2011. So this would have been after the point at which you had done at least a fairly significant amount of interviews with the employees at the Early Learning Center, and after your firm had been working on the case for roughly 5 months or so, right?
Yes.
And what I wanted to take a look at in particular was, do you remember, or do you see actually, in this October of 2011 letter where I am at least positing my interpretation of the policies and my belief that there's at least $4 million in coverage of not 12.
Yes, I see that in paragraph 2.
And so did you discuss the coverage issues with your clients, and the clients at that point I think were the Olympia Early Learning Center, probably specifically? Did you have a discussion with them about insurance coverage at that point in October of 2011?
I do recall discussions with my clients about insurance coverage limits, and I assume that I would have had them before now, but I actually don't recall the precise timing of those conversations.
And I think you'll agree with me that you certainly had conversations about insurance coverage late in the game in 2012 and 2012, but specifically, you remember having this discussions with your clients in the fall of 2011 when the issues were first being raised.
Specifically, I don't, but I strongly suspect that I did.
Do you remember having let me put it this way. Do you remember having communications with Philadelphia Indemnity about either my interpretation of the insurance coverage or their interpretation of the insurance coverage?
Yes, I had those conversations with Jackie Holdeman, who was the claims adjuster.
And again,
I'm sorry.
The claims adjuster?
so I want to try to be as specific as we can about the timing, Mr. Bolstein, because I know you had discussions with Philadelphia Indemnity in the fall of 2012, but are there any documents showing communications that you had with Philadelphia Indemnity in the fall of 2011 that I was raising the coverage issue?
I don't know if there are documents or not. I do recall discussing this letter with Jackie Holdeman after I received it.
Right.
And I may have forwarded it on to her, but I definitely discussed it with her.
Right. You'll see in the second kind of full paragraph of this letter where I'm talking about going to Oregon to take depositions designed to help determine what the insurance coverage is down in Oregon with the broker for OELC, Slater and Associates. Do you see that?
I do.
And do you remember whether your clients, did they oppose a deposition of the broker to try to pinpoint the insurance coverage at that point?
No.
And did Philadelphia Indemnity oppose that happening?
I believe they did. I think there was a proceeding in Oregon that I was not directly involved in where I believe they did oppose it and no deposition was taken.
On the bottom, you'll see, and into the second page, that I mentioned in this letter that I was familiar with Philadelphia Indemnity from a prior case called the Business Computer Training Institute case, which we'll see over on the second page as well. And that I was expressing concerns to you that Philadelphia Indemnity had a history with me of misinterpreting their policies. Did you have a discussion with your clients about that issue at that point in October 2011?
Back to the question, Your Honor, the question itself is fine. The preamble to the question is testimony.
Already heard that.
Sustained.
So, Mr. Bolstein, did you have a discussion with Philadelphia Indemnity? Did you have a discussion with your clients at that point in October of 2011 about concerns that I expressed in this letter as to Philadelphia Indemnity and a prior case?
I may have, but I don't recall.
Okay. Did you have a discussion with Philadelphia Indemnity about the concerns that I expressed in this letter as to the past case I had?
Your Honor, I'm going to check down and see how this is relevant.
Overruled. You may answer.
Yes, I talked about it with Jackie Holdeman.
So let me have you turn to Exhibit 75. I'll give you a chance to orient it now after the advisors what this document is and you understand it.
I believe this is the letter that I could not find in my file or in my email after it was brought to my attention by Jackie Holdeman in the fall of 2012.
Yeah, you'll see in the letter that this is specifically a policy limits demand, at least as it's entitled, right?
Yes.
And you remember, well, let me ask you this. I'm going to skip this ahead for a second. And have you take a look at Exhibit 72.
I'm there.
So There was 75 was the December 1, 2011 policy limits demand. And I'm now having this look at exhibit 72, which is a July 20, 2012 email exchange between us. And down towards the bottom, let me see if you see this part where it says, Mike, I wanted to make sure somebody over at Philadelphia Indemnity let you know that the motion for protective order was granted, so the death is off for Monday. I think we touched on this briefly last time. That was an attempt by me to depose Philadelphia Indemnity in Pennsylvania on the issue of insurance coverage. Remember that?
I do have a vague memory of that, yes.
Okay. And then the next sentence is what I wanted us to focus on. It says, I also wanted to make sure you received our policy limits demand. And you respond, here, where you say policy limits demand, if you mean a recent demand, no. If you mean a formally demand from a while ago, yes. And you were referring at that point back to that December of 2011 policy limits demand that we see in 75.
I wasn't, because I don't have any record or memory of actually receiving this. I may have been responding to this October 21st, 2011 letter, which I passed on to Jackie Holloman as a, your thoughts about policy limits. So I'm sorry, I just don't recall ever receiving the December 1st letter. And when Jackie Holloman brought this to my attention, I checked our hard copy file, I checked my email, and I just didn't find it there. So.
But at least in terms of a policy limits demand, a $4 million demand, the only other one that there's evidence of is the December 1, 2011 policy limits demand that we see in exhibit 75 or 72.
I think I was interpreting our conversation in that October 21st letter as a demand. And I believe I responded to your email without actually, checking my files or anything of that sort. I was just relying upon my memory when I responded.
Okay. I don't have it right in front of me, but I'm going to give this in a second. Do you remember there being a December 20, 2011 email exchange that I had with you about some
Preamble. Remember there being a December
20, 2011 email that I had with you where I pointed out that the policy limits demand was expiring at 5 p.m. The evening before.
No, I'm sorry, I don't.
Correct. All right, so we'll bring that in then. So let me turn our attention now. So I want to go back to exhibit 75 just to get our time frame down here. And then have us take a look at exhibit 66. We skip this ahead from December 1, 2011 in February of 2012.
I am there, yes.
All right, tell us what exhibit 66 is, if you would.
This is a letter that I wrote to Jackie Holloman with my opinions regarding the case thus far.
Okay, so I think we've looked at some pieces of this before, but it essentially explained to us what the kind of the body of material is that you digested through the document.
Yes.
Mr. Bolsino, I was going to have you just kind of summarize for us what the body of the information is in the 66 of your paper.
Oh, yeah, well, the first part of the letter is the factual background. The second part of the letter actually discusses each of the plaintiffs and some liability issues associated with that. Second part of the letter discusses damages, or third part of the letter discusses damages. And the last part are some issues with respect to settlement and mediation.
Right. And so, yeah, I think we touched on this a little bit in the first session with you when we showed paragraph 9 of this Exhibit 66, just to reorient us to some of the issues that you raised then in February of 2011. And that would have included the fact up on top in the highlighted section that we see that you felt that the most significant damages claims were by SA, right?
Correct.
And you explain why. And then down towards the bottom in the second highlighted section, we have the discussion that you had about the damages to the parents being significant as well, right?
I think I used the term more significant than when I was referring to certain of the parents.
Right. For example, Lisa Steele herself, right? Whose daughter she reports to have been molested by Eli Faber, right?
Yes, I thought that their sincerely held beliefs that their children were molested would increase their damages.
On the last page of this Exhibit 66, you raise the issue and write a little about the issue of the settlement and possible mediation, and you note within this that I believe at least that there was $4 million in coverage and willing to settle for those policy limits at that time, right?
Correct.
In fact, you used the term yourself that plaintiff's counsel believed that the policy limits were $4 million, and he is willing to settle for policy limits for all 6 of his claims, right?
Yes.
Indicative in February of 2012 that you knew fairly recently that we had made a policy limits demand of $4 million, probably in December 1, 2011, right?
At that point, I felt with information that you had given me that you believe the policy limits were $4 million and that you would accept it.
And down towards the bottom, or actually that last paragraph, you are indicating there at that point in February of 2012 that you believe that SA's claim alone could, as you put it, justify a settlement of $1 million, right?
That is correct.
And by that, I'm inferring, you tell me if I'm wrong, that you believe that a jury verdict could be higher than the settlement amount you were saying could be justified at $1 million, right?
Yes, because the settlement value and what a jury could return are often two very different things.
Right. And that's a fact that we found out later in a Catholic Archdiocese order case that Mike Found I obtained a verdict in that summer of 2012, right?
I don't know what your question is. I became aware of a verdict that summer of 2012, but I don't know what you're asking me to comment on with respect to that.
That a settlement figure that you might write about is less than what might happen in the jury, right?
Oh, yes.
And my question was that played itself out later that summer with this Catholic order case that Mike Found I obtained a verdict with, right?
I guess that's the part I don't understand. When you say it played out, what do you mean by that?
Sustained.
Do you remember having written, in fact, the Philadelphia indemnity that you had thought the value of the case and that a case against the Catholic order was 8 times less than it turned out to be with the jury verdict?
Yeah, based on what I had heard about the case, yes, I was surprised at the size of the jury verdict.
And do you remember having expressed the Philadelphia indemnity that you had underestimated its value based on how the jury came back?
I think I said that I underestimated its value based on what I knew about the case. So yes, sort of.
So that's February 21 of 2012 when you are preparing this report to the Philadelphia indemnity. Do you remember ever preparing a litigation budget that you gave to Philadelphia indemnity?
Yes.
And tell us what a litigation budget is.
It's basically an estimate of how much it would cost to take the case through various stages, including trial. in defense fees and costs.
Is that something that you typically do in a case?
No, I mean, it depends. The insurance companies often seek that. The risk management pools, who I do most of my work for, particularly today, do not.
Why don't I return to Exhibit 116?
I think I may need another book. This says the 130. Oh, I see. There are these tabs here at the back. Got it. Okay, I am there.
All right, I'll give you a chance to orient it in. For a second. All right, so we see here on the first page of Exhibit 116, the Tuesday, February 28th, 2012 date, right?
Yes.
And remind us, was that a week after you'd sent your kind of summary of the case and assessment to Philadelphia Identity?
Yes.
And so tell us, we're going to take a look at the second page. And that's the page that's headed Philadelphia and Insurance Companies Litigation Plan and Proposed Budget. Why did we prepare this?
Because Philadelphia asked me to.
And so how did you go about doing it?
I basically, I believe the activities were already filled in, and I checked, yes, would they be required for this case or not? And then, you know, the projected number of hours and based on my hourly rate, the projected cost. So it was basically, it's not scientific at all. It's just rough estimates of how long things would take and what they would cost.
And so, as I understood it, then this is a Philadelphia indemnity form. Is that right?
It is.
And so they send this out, at least as you understood it, to their attorneys to get a proposed budget.
Yes.
And so they have a discovery section I see, and then they have a pretrial section that we see down lower on that second page, right?
Yes.
And then the third page, if we look at that, is a trial section. And
Yes.
your proposal was that a budget would be needed of about 242,000. Is that right?
Yes.
And understanding that these were just kind of estimates on, this was your good faith estimate of what it would cost to litigate the case. Is that right?
Yes, at the time.
And you made a note down here on the bottom. Tell us about it.
It says the budget is for the Steele Barbieri case that, for example, a lot of the depositions that I attended would apply. It would apply to all. I think 3 of the cases are actually 4 of the cases, if you count the one that you filed against Steve Horgdahl and Rose Horgdahl and Steve Olson. So what I was saying was, if there was an individual budget for each case that a lot of the work done for the first case would apply to the others as well.
But as I'm understanding, there would be overlap between what you did originally in the Steele case, but then there would be additional costs for handling each of the other cases. Is that right?
Yes.
And so let me go back to the second page and ask. Well, first of all, let me ask you globally: did Philadelphia Indemnity approve this budget plan when you proposed it in February of 2012?
I don't recall.
Okay. Well, is there any is there any written communication that you've ever seen in which Philadelphia Indemnity approved this proposed budget?
Not that I recall today.
And did you take any of the non-expert depositions, the 20 some odd that you had identified in the budget plan?
No,
Did you take any of the depositions that you indicated should be taken in the experts category?
no,
Down lower, we see the section on summary judgment. Did you file any summary judgment motions in any of the cases?
no.
Did you file motions to eliminate in any of the cases?
I don't believe we got to that point, but no.
By the way, as to any experts, do you remember plaintiffs offering the depositions of their experts for you to depose?
I don't recall one way or the other.
But ultimately, you didn't take the depositions, true?
Correct.
Well, one issue I wanted to touch on as we look at the summary judgment issues and the motion to eliminate issues is this issue about the Tegman defense. Tegman as to whether it applies in a sexual abuse case. We don't need to have a debate about that, but let me ask you, did in any of your written communications with Philadelphia, you address a feeling that Tegman would somehow reduce jury verdicts or the value of any cases?
I don't recall. I mean, I recall what I thought about Tegman and how it would apply at the time. I don't recall whether I addressed that with Jackie Holloman or not.
In any of the materials that have been reviewed in the last 8 years in preparation for this hearing, have you seen any written communications of yours suggesting that the Tegman case somehow applied to reduce the value of any of these claims in the Steele case?
I don't know. I mean, you say you act like I've been reviewing documents over the last 8 years to prepare for this hearing. And I reviewed documents before my testimony last time, and I tried to review documents before my testimony today, but I didn't catch everything. So
I was asking for your best memory.
yeah, my best memory is I don't recall telling Jackie Holloman that Tegman would be a factor at trial to reduce liability.
Thank you. So this budget plan was February 28, 2012. Let me move this ahead in time to Exhibit 70, which we'll see in late March of 2012.
Okay, I am there.
All right. And so just orient us to what we're looking at.
This is an email exchange between you and me, dated March 15th. Well, the first parts are dated March 15th, then March 25th, then March 26th, 2012.
All right. So down at the bottom, March 15 at 3:47, I'm asking about whether you're going to be at the status conference for the case, right?
I see that.
And then you responded you're going to be in Lewiston, but I want to focus on this highlighted section here in the middle, where it says, Mike, you and I have discussed setting up a mediation to address coverage issues with the Philadelphia Indemnity Sexual Abuse Endorsement. It seems like it makes sense to do that earlier than later. Did Philadelphia, let me ask it this way. Did you have a discussion with Philadelphia Indemnity here in March of 2012 about my interest in getting a mediation set up to discuss these issues?
I don't recall when I had the discussion, but yes, I actually had several discussions with Jackie Holloman on that issue.
Right. And did Philadelphia Indemnity authorize the mediation here in March of 2012?
No.
In April of 2012?
No.
In any of the months after this in 2012?
Yes, although I was not involved in that process. I believe that through Paul Rosner, they authorized a mediation maybe in July or August of 2012. I saw emails about it, but it wasn't communicated through me.
Do you remember attending any mediation at all at any point in this case?
No.
So this is March of 2012, actually March 26th. Let me turn us to Exhibit 88. In fact, we'll have a part of this 88, 89, and 90 as well.
I actually can't see that. So I can see the thing in front of me, but when you're orienting me to a document, I can't see what's on the screen.
All right, thank you. Is that better?
Oh yeah, that's much better.
Connor, is that okay for you?
Yes, thanks.
So exhibits 88, 89, and 90 are all amended case schedules coming out of the Thurston County Superior Court. Is that right?
Yes.
88, for example, is in the Steele case specifically.
Correct.
And the date that we see it filed was March 27. Right?
Yes.
Right? And the trial date for the Steele case is October 16th of 2012.
Yes, I see that.
And then you see in exhibit 89, it's the same form of the document, but this one applies to the Myrick case.
I see that.
Okay. And the trial date for this one is October 29, 2012, right?
Yes.
So on the heels of the Steele trial, right?
Correct.
And exhibit 90 is the Mendoza case.
Yes, I see that.
And the trial there was November 13th, right?
Correct.
So on the heels of the Myrick case.
Yes.
All before Judge McPhee, right?
Yes.
Okay. So let me now move us forward in time with exhibit 114.
I am there.
And orient us to what this document is.
This is an email exchange between Steve Olson and me in May 3rd and May 4th of 2012.
So let's look at the top portion where Steve Olson is emailing you with a sentence that starts, Kim still feels that we need to get a divorce to protect her assets. So I suspect we will move forward with that. Do you remember this being a communication back and forth between you and Mr. Olson after the plaintiffs had filed specific individual suits against Mr. Olson and his portfolio?
I do.
All right. And so you remember having discussions with Steve Olson about his concern of being exposed to excess verdicts in such a way that he and his wife might have to get a divorce.
Yes.
And you see the discussion specifically here where it says, I guess Kim's understanding of the situation is that if Philadelphia digs in and says no more than 1 million, and the courts give more than this 1 million, that Rose and I would have to make up any difference. If this is true, then I'm worried as well as Kim. You see that?
Yes.
Do you remember having discussions with Ms. Horkdahl similar to the discussions that we see here with Mr. Olson?
Not about divorce, but yes, about policy limits.
Right. And do you remember having discussions with Philadelphia Indemnity in this period of May of 2012 about the concerns of the individual defendants as to excess verdicts and excess exposure?
I don't recall that I did.
Do you remember whether Philadelphia Indemnity took any action to address the issue of the coverage and what was available on behalf of its clients? It's injury. Let me rephrase it. So do you remember whether Philadelphia filed a declaratory judgment action in the spring of 2012 to address coverage issues?
No, they did not. I recall there was an interpleader action filed in the summer of 2012.
Right. In fact, sometime in either in late August, right?
I don't recall when it was filed. I do know it was the summer of 2012.
So did you take any specific action in May of 2012 on behalf of your clients in the litigation, either Mr. Olson or Ms. Hordahl or OELC, in terms of getting this issue resolved or figured out?
I did actually refer Mr. Olson to Will Ashbaugh as somebody who was an insurance coverage attorney who could assist with respect to coverage issues vis-a-vis Philadelphia.
Do you remember on the timing of that?
I don't, although it's probably, there's probably documentation about when Will Ashbaugh first got involved.
So here we are in early May of 2012, but before we go on out any further, let me mark exhibit 131, which is the December 20, 2011 email that I mentioned, Young Man.
Yes. Thank you.
Policy on hand with the mark exhibit 131.
Thank you.
I'll give you a chance to read that. December 20, 2001.
Yes, I've read it.
So I was going to draw your attention down to the second paragraph where I'm talking about the records that we received from Division of Licensed Resources, their finding of negligent maltreatment, specifically against Ms. Hordahl. And then I'd say there was no small bit of irony as I was reading it over again last night at about 5 p.m. as our policy limits demand for Philadelphia indemnity insurance expired. You see that?
I do see it.
All right. And this would have been an email that you would have received, right?
I don't recall it, but I can't say whether I received it or didn't receive it. So
I want to take us back into May. So I'm just going to keep walking us through. So let's go to exhibit 71.
okay.
So you see that we're in May 18th of 2012, so a couple weeks after your conversation or communication with Mr. Olson. And we'll see your email starts it saying, I spoke to the Philadelphia Insurance Company claims adjuster. She's going to recommend a mediation on coverage issues and get coverage counsel from Soha and Lang involved to see if we can make progress on this issue. And the Soha firm is here today with us. Mr. Rosner and Ms. Denny,
right? Yes.
And then my response is in the affirmative, right? Sounds good. On the topic, we're setting up a 30B6 step for Philadelphia indemnity, and we need available dates from you and your folks, right?
Yes, I see that.
In this deposition of Philadelphia indemnity, trying to get coverage information and trying to get this locked down was a deposition that ultimately you understood Philadelphia indemnity resisted right?
Objection, Your Honor, this is not relevant to the reasonableness hearing. It's far beyond the scope of this witness's involvement or knowledge. This is a different, now talking about a different litigation. Not this litigation.
Mr. Cochran.
We actually have addressed the issue because I had email communications with Mr. Bolasina about the fact that he didn't have to fly out to Philadelphia because it had been quashed by Philadelphia. So I think we've already looked at this in evidence.
Okay, the objection is sustained.
Okay. So, Mr. Bolasina, I'm going to have us move to exhibit 71. So we're moving forward in time.
I think I was on 71.
So number 20. Thank you.
What exhibit?
Exhibit number 20.
Okay, I'm there.
So now, late May, you remember me forwarding you a copy of our expert, Dr. Matt Logan's report on Eli Tabor and Eli Tabor Livingston.
Yes.
He was forwarded to exhibit 76, July 19th, 2012.
Oh, now 676?
76.
Yes.
Right? And explain for us what exhibit 76 is.
It is a letter to me from you dated July 19th, 2012.
And you recognize this as being the policy limits demand that was made by the plaintiffs on July 19th, 2012.
Yes.
And at the time, the policy limit demand was for $4 million, right? If you look down at the,
I'm looking on page 2. So, yeah, I'm seeing the number 4 million in several places.
all right. And was this a letter and a settlement communication that you then forwarded to your clients? Clients being Steve Olson and Ms. Fordahl and OELC?
I don't recall that I did.
Is there been any reason why you wouldn't have sent a settlement communication to your clients?
Because they're lay clients and they probably wouldn't understand it. So I doubt that I sent it to them.
Did you send it to Philadelphia Indemnity?
Yes, I would have sent it to Philadelphia.
Do you ever remember having discussions with Philadelphia Indemnity about it?
I would have. I don't recall them right now, but I'm certain I would have.
And you remember at some point that $4 million number being reduced to $3.95 million as a demand in order to allow the defendants themselves to have remaining insurance coverage and a remaining defense of the cases.
I do recall that the demand was reduced by like $5,000. But I don't recall what that sounds like what you were doing, but I don't recall what your incentive was for doing that.
You remember being a recommendation from yourself and Bill Ashbaugh to make sure that there was continuing defense coverage.
I don't recall, but that sounds correct.
So Exhibit 72 we looked at briefly already, but let's continue our march through time since that was July 19 and this is July 20. This is the email where we talked about the fact that the Philadelphia Indemnity insurance deposition had been canceled. I was hoping that they were communicating with you. You go on to say in the middle there, I'm sorry, this got.
Excuse me, I don't know what exhibit we're on.
72.
This is a little messy right now, I apologize. But in the middle, you're saying, thanks for the info, I have not heard. Policy limits demand, if you mean a recent demand, no. If you mean a 4 million demand from a while ago, yes. Rosner agrees that a mediation with Harris is a good idea. I'm not sure how to get Philadelphia to move forward on this suggestion, except to take steps towards scheduling this. Are we good with this, right?
Yes, I see that.
Right. And the issue of not knowing what to do to get Philadelphia activated and getting this resolved was a regular theme throughout that summer of 2004.
Overruled, you may answer.
I don't agree with that, except for getting approval for the mediation. I do agree that getting approval for the mediation took a lot longer than I thought it should.
Let me maybe take a look at Exhibit 67. Which is 3 days after the policy limits demand went in. You on 67?
I am.
All right, and do you recognize this as being an email exchange between the main adjuster for Philadelphia, Jackie Bowman, and her boss, Suzanne Houster?
And I've actually never seen this document before, so I'm not familiar with it.
And I won't ask you about it. Let me move forward in time to Exhibit 68.
I'm there.
All right, and you recognize this as being the email communications that you were having with Philadelphia Indemnity?
Yes, I do.
And so let's start down at the bottom here. On August 1 of 2012, you're communicating with Paul Rosner, who's the coverage counsel for Philadelphia, and you are attaching a letter from me that day, is that right?
I am.
And it was in response, as you noted, to a letter that you had sent out on behalf of Philadelphia rejecting the policy limits demand, right?
Yes, that's how it's described in my email.
And by the way, at the point that you were writing a letter rejecting the policy limits demand, had you discussed that course of action with defendants Steve Olson, Rose Hordahl, or OELC?
I'm sorry. I think you were rejecting the policy. Wait, it is response to my letter. Okay, got it. I don't recall whether I did or not.
Were you supposed to have consulted with your clients, the actual clients themselves, before rejecting the policy limits demand?
I did consult with them about issues regarding policy limits. It's just 10 years later. I just don't recall, any particular conversation I had with them around this time frame.
I'm trying to be more specific about the timing. Prior to the point that you sent out a letter rejecting the policy limits demand in late July of 2012, had you consulted with and obtained permission from your clients, Olson, Hordahl, and OELC?
I likely consulted with them, but I did not obtain permission from them to do that.
So the correspondence goes back and forth, and then up top we see this section saying, in closing, Cochran invites discussions on the issues raised. And by issues raised, were you meaning the policy limits?
Yes.
Right. And you note that Paul Rosner is in a better position from a knowledge base to discuss coverage limits, interpleader action than other issues raised. And the Paul is Paul Rosner. Right?
It is.
Right. And is it fair for the court to infer that you were in discussions actively with both Philadelphia Indemnity and Paul Rosner at this point when policy limits demands are being rejected?
Yes, definitely. I'm in discussions with Philadelphia about their decision to reject the $4 million demand. Or it might have been the $3.995 million demand at this point. I don't recall being in active discussions with Paul about this. And I was definitely in active discussions with Will Ashbow about this because he was the person I was relying upon for advice on insurance coverage issues.
And here in this late July, early August time period, you write the term interpleader action. Had Philadelphia Indemnity advised you that it intended or was considering filing a federal lawsuit against the defendants themselves to limit coverage?
I don't know if they told me that it was going to be in federal court, but they did tell me that I obviously, because I put this in the email, that they had raised the issue with me. That issue would not have been raised by me first.
And so did you have discussions in this time period in late July and the 1st of August with Mr. Olson or Ms. Hordahl or OELC about the impending potential that Philadelphia Indemnity would file a lawsuit against them in an effort to limit coverage?
I don't think that I would not have described it that way. But I did tell them after the interpleader action was filed what had happened and what the purpose of that was and how it might impact the claims.
So it sounds like after the interpleader action was filed in late August that you talked to them. But my question is, at the point that you were being advised that this was in motion by Philadelphia Indemnity, did you discuss with your clients the fact that this lawsuit was coming soon against them?
No, I don't recall that I phrased anything that way.
And did you have a responsibility under the rules to have advised them of what you were learning from Philadelphia in terms of an interpleader action being filed against them?
Objection. Rollins,
I think this I think this witness is qualified to answer that question, at least offer an opinion, so the objection is overruled.
Yeah, I did tell them what was coming. I just don't, I did not advise them that this was going to be an action against them to limit insurance coverage limits. So I don't recall ever phrasing it that way in my conversations with them.
My question though is, should you have given your
I don't know.
So in this same note that we see here in Exhibit 68, you see a note that you actually wrote, and I know that we've talked about this a little bit, but let me address it with you. The fact of this $8 million verdict that came down in Mike Fow's case against the Archdiocese order.
Yes.
Again, this last line you got here says that $8 million was about 8 times what I thought the case was likely worth based on what you knew about.
Yes, I did write that.
Let's march forward in time and let me have you take a look at Exhibit 73.
I'm there.
And to orient us up on top, at least the timing, we've got August 1 of 2012. There are emails being exchanged back and forth, right?
Yes.
And you are one of the people who's being copied in the letter, right?
Yes.
And let's start down at the bottom, though, where you were writing to John Masterson, and remind us who John Masterson is.
He was the chairperson of the then defunct board for Olympia Early Learning Center.
And was this the first time that you had communicated with John Masterson in a very long time about the events going on in the case?
No. Why do you see that? Why do you say that?
Take a look at the top part.
Right.
This is the email from John Masterson to Paul Meyer. It says it's been some months since we corresponded. And I understand that it's Mr. Masterson.
He's talking to Paul Meyer, not me.
But he says, I spoke today with Mike Bolasina, OELC's defense attorney, about the attached letter from OELC's insurance company. It seems that the insurance company is dragging its feet on resolving the coverage limits issue in this case. You see that?
Yes.
All right. Then it goes on and says, Mike Bolasina asked if you would contact him to assist in motivating Philadelphia insurance into action, right?
Correct.
All right. And so I asked earlier about whether this was kind of a regular discussion topic for you about needing something to motivate Philadelphia Indemnity into action. And we see that at least here in August of 2012, right?
Yes.
All right. Let's go to exhibit 85. Nope. Exhibit 119.
Yes, I'm there.
And so explain for us what this is.
I think this is the same letter that I was referring to in Exhibit 73. This is me actually forwarding it on to Rose Hargall.
All right. Again, the subject matter being excess insurance exposure or excess exposure beyond the insurance limits that Ms. Hargall was facing, right?
I don't know. It references a letter from Philadelphia Insurance Company, but sitting here today, I don't recall what that letter was about, other than I describe it as regarding coverage limits, settlement demands, and potential settlement of the case.
And then she has questions for you about what lawsuits are out there and when they start, right?
Yes.
And then you go on and provide some explanation. You say, to be accurate, there are 3 lawsuits against the center, the trial starting in October.
Correct.
You explain that because there are 6 plaintiffs and there are lawsuits in 3 different sets, right?
Yes.
You say if Philadelphia Insurance Company does not take some decisive action to resolve the claims, it is possible that the October trials against the center will actually happen, right?
Yes, I wrote that.
And then maybe to assuage her concerns, you say things will very likely be resolved one way or another by April when the trials against you and Steve begin.
That was what I truly felt. I wasn't just saying it to assuage her concerns.
So let's go to 85.
Okay, I'm there.
So you were a courtesy copy recipient. You see on the bottom of this letter from Paul Meyer to Mr. Rosman, and on August 23 of 2012, right?
Yes.
And Mr. Meyer, you'll see, is asking Philadelphia Indemnity to treat Learning Center's interests equally with its own, right?
Matter, Dixon Road and moving forward from the witness, and then you have to do the lawsuit.
Mr. Cochran?
There's an exploration about whether there was collusion, bad faith, and fraud. This is part of the overall analysis of whether that existed or clearly or not.
Overruled.
Mr. Bolson?
Actually, I've done that, which many witnesses done. I've forgotten the question.
All right. So
I'm sorry.
That's right. Let me ask you a new one. You see here that Mr. Meyer, Paul Meyer, on behalf of the Olympia Early Learning Center, is asking Philadelphia Insurance Company to treat its interests equally with those of the Learning Center, right?
Yes.
And by the way, did you prepare a letter like this on behalf of any of the defendants to Philadelphia Insurance Company at any point?
Not that I recall.
You see Mr. Meyer here doing it for the Olympia Early Learning Center. Did you prepare one ever for Ms. Hordahl of a similar nature?
Not that I recall.
Let me take you down to the bottom here where it says, in addition, in light of Philadelphia Insurance Company's decision to file an interpleader action in federal court, naming the Olympia Early Learning Center as a defendant, this letter is intended to inform the Philadelphia Insurance Companies that the Learning Center will consider any action taken in the interpleader action that compromises the Learning Center's rights under the applicable insurance policies to be an act of bad faith. You see that?
Yes.
Did you write any similar correspondence on behalf of any of the defendants at any point?
Not that I recall.
And prior to the point that Philadelphia had filed that interpleader action, did you discuss with Philadelphia concerns that filing an interpleader action may compromise your defense of the case on behalf of the defendants and present an issue of that?
Actually, I was actually relying upon Will Ashpow to make those, to take those positions with Philadelphia Insurance Company, and I suspect that he is actually the author of the letter that Paul Meyer wrote.
Right. So let's take a look at 86, which might compare that out. Let me know when you've had a chance to orient to it.
I'm there.
All right, and we see this is an August 23, 2012 letter written to Mr. Rosner, and this is from that same Will Ashbaugh.
Correct.
And you are courtesy copied on this, as of Mr. Meyer, right?
Yes.
And includes many of the same issues that were addressed by Mr. Meyer to Mr. Rosner, right?
Yes.
And again, expressing concern that the interpleader action may constitute an act of bad faith, right?
I'm looking to see if that language is in here.
I've highlighted it on that bottom paragraph.
Yes, I see it.
So let's go. This is August 23, 2012. Let's turn to Exhibit 82. As we march forward in time, the very next day, August 24.
Okay.
And tell us what this is. Do you recognize it?
I recognize it from my deposition, and it's a copy of the interpleader complaint.
And you would have received a copy of this at the point that it was filed August 24, 2012, or thereabouts, right?
I don't recall, but probably.
And one of the reasons you probably would have received it is because you were representing the defendants at that point in litigation, right? Including the Early Learning Center, Ms. Fordall, and Mr. Olson. Okay.
Well, I don't know if I was representing them in this case. So I don't recall whether I received a copy of this as defense counsel or not.
You do remember receiving it in some capacity, right?
Yes.
Right. In fact, you you were asking questions of Mr. Rosner in the days after this about whether he had served the interpleader complaint on plaintiff's counsel, right?
I don't recall. There may be an email or something that would refresh my memory.
Let's take a look at Exhibit 121.
Yes.
And it says, does Daryl know yet about the interpleader action having been filed? Have you sent him a copy? Maybe you wanted to say, if so, I would like to approach him about staying the October trials, right?
Correct.
And you did telephone me about these topics, right?
Don't recall.
Let me show you Defense Exhibit 95. I'll have to get a defense binder, so hang on 1 second.
That would be 595, I think is what it technically is.
Thank you.
Mr. Wilson will be pausing around the court to find it. They tend to do about 595.
Yes, I see exhibit number 595.
All right, you'll notice that this is an email correspondence I had with Bill Ashbaugh on August 31. But the significant part for you is the section where it says, I spoke to Mr. Mike Bolasini yesterday, and he asked me about whether the Philadelphia indemnity deck action had any impact upon our plan, and I advised him that it has no impact on our intention at all. And Mr. Bolasini, what I'll look for is whether this seems consistent with your memory as I read this.
Yeah, I don't have any memory of that conversation, so I can't say whether it's consistent or not.
Let me ask you specifically about this point. And let me read from the exhibit. As I pointed out to Mike, Philadelphia Indemnity only filed this deck action after the third and final effort by me to require them to settle the case within policy limits, and probably only because I pointed out to them that it should have filed a deck action long ago to clarify the coverage issue. Do you remember a discussion that you and I had about that?
I don't.
Do you, let me read this portion to you. Where it says, let's see here, where it says, oops, that we must secure judgments, right here. We must secure judgments against the defendants, and we can do that by proceeding to trial and securing jury verdicts that we will then seek to enforce against defendants. Or we can do it based on the consent judgment settlement offer I have made to defendants, now that will protect them from the jury trial and from execution proceedings against their assets. A step which would drive one or all of them into costly and damaging bankruptcy proceedings. You remember having a discussion with me on that topic on roughly August 31st of 2012.
I don't remember having a discussion about consent judgments with you. I do recall having a conversation about that with Will Ashbaugh. I'm not saying I didn't, just that Mr. Cochran, I just don't recall this conversation with you one way or the other at this point.
Okay. So let's move forward to exhibit 69.
Back in the white books?
Yes.
Right? The other.
From August 31, 2012, now to September 14, 2012.
Okay, I'm there.
And I think there's been a fair amount of time spent with this verbatim recorded proceedings on September 14, 2012 in front of Judge McPhee. So we don't need to spend more time on that. So let me have you take a look at exhibit 126.
Oh.
Sorry, I'm going to exhibit 122.
Okay, I am there.
So orient us to what this is, exhibit 122.
This is a letter that I wrote to Jackie Holloman at her request, allocating the $1 million. And it was what Philadelphia considered as policy limits to your clients and to ND and his mother.
So I think exhibit 122 is the letter where Philadelphia Indemnity is asking you to do an allocation. On September 18, they sent this email to you saying Philadelphia Indemnity Insurance Company would like to tender the policy limits of one way and two claims.
That's not numbered that way on the set I have, but this is my 122. Looks like this. 121? 121 is. Uh, 121 is the email from me to Paul Rosner about does Daryl know yet about the interpleader action? That's my letter to you with the allocation of the policy limit demand.
I apologize for interrupting. We're going to take our morning break. 10:20, we'll be in recess until 10:40, 20-minute break. Thank you.
Thank you.
All right.
I'll figure it out.
I'm getting used to it.
Oh, what can I do to make it easier for you?
Stand right there. Take down those
I never-
plexiglass screens.
Yeah, and
Take out the mask.
I thought that the cage, the plexiglass cage was so I could go maskless behind it.
I moved this desk forward a little bit. Is that right there?
What that?
I just moved this desk.
Oh, that's fine. Yeah.
So you can't.
No, I'm good.
Thank you. We got Mr. Policy now. I asked him to talk to him. It was like. Well, we haven't gotten the price. I assume it will get it.
I found it, but you, yes, I figured if I kept driving. Yeah.
It's like,
We have it sold.
Yeah, I saw the list come through and yeah.
which was forwarded.
All the way around.
Witness, yeah.
Stuffing in.
We're all with that.
Then we're gonna screen it.
Yeah, oh gosh. I didn't even know that.
Then it's in the
Yeah, it's Starbucks and now it's cool place to sit down and yeah.
I've got 122 and 123 backwards. So.
Oh, okay. I thought you were actually questioning me about an email from Jackie Holloman asking me to do the allocation.
Yeah, that's 120. Your 120.
120 what? My 120. Oh, okay. Ah.
Yeah. So there's back.
Got it. Okay.
So
I see it.
we'll start with 123, then go back to 122.
I remember in New York City, walking down and watching yeah, so go in and Give $5 and $15.
I'll have to read it last time. Black coffee. Yeah, I read this.
What's that?
I haven't read it.
Perfect.
There's just sending you an email number.
Yeah.
Oh, yeah, yeah, yeah. So that's something, a bunch of grapes, original, that I had to try on, it was a wonton. Those kind of, I didn't know, eating it,
I had intended to go and then with my mom, I haven't been able to hospital yet, but she got it before I just sort of didn't feel.
But just that it was a long one of fire, I was on some of those, gas and everything like.
And I even have to do parts. I have posted a. With a long stop and I got a bunch of speech. One of his things is he was gender, which is basically he said I did that
I was kind of surprised. No, I honestly don't have that. I'm trying to get down. Well. A little bit. But I get it. Yeah.
You're very welcome. They should be identical. So now we don't have yeah, they should be exactly the same. You're very welcome. Thank you for reminding us.
Yeah. You're gonna stand up, right? Should give you one of those desks. I didn't get any of that. Aaron tried to bring that to the previous sentence, because I missed it. Yeah, and the after. Oh, that's, yeah, that was right.
Seahawks defense is so bad, we can beat them with that. We're running back.
Oh,
Yeah, he's the one who started the country.
yeah. Aaron Rodgers is on fire.
Yeah, that is a bad break. I just read that myself. They must have that running rampant through their locker room.
well? Was he an anti-accident?
I don't know that. You don't have to see it pretty, but it's not.
Oh, no. You know, you can see on TV where they was living in. Yeah. It's like, he was all started. Yeah. He was like playing with the track. And what one of my partners, probably didn't see it, right? And so then I'm looking at the hospital. Yeah. And then of course, he was back and he did great. And so we had to, we're so out there. No, he told me he's not taking his anymore. Yeah, he's still feeding that. I think he might I'm pretty good at it. I'm good at hiding. Yeah. He made a good meeting. All right. We're just in discussion.
Please be seated. Thank you. Mr. Cochran, you may continue.
So this policy, let's go ahead and go 123, and we'll make sure that we've got the right exhibit. So you tell me what exhibit 123 is.
It is an email from Jackie Holloman to me, dated September 18th, 2012.
All right, is it this email that we see up on the screen?
It is.
All right, very good. And so she asked you to do an allocation of $1 million that they were going to offer, and that would be between not only all of the plaintiffs in suit, but also this boy ND who had not filed any claims, right?
That's correct.
Even to this day, roughly 8, 9, 10 years later, he still hasn't filed any claim.
I have no idea.
And so then you went about this in this allocation, right?
I did.
And we see that in exhibit 122, is that right?
Yes.
Got the right document up on the screen?
No, Your Honor, I think the last line is 122.
We got to going through this right now. So the official exhibit is this. So that's why we're going through section down.
Yeah, I'm just trying to make sure that the record's clear on what exhibit we're on. And I know.
Well, that's why I diligently walked through this. So exhibit 123 was the September 18, 2012 email from Jackie Holloman at 8:55 to 34 a.m. like Orsina. And exhibit 122 in the official record is the breakdown. Is that right?
Yes.
Mr. Lavison, do you have that in front of you?
I haven't switched, but I do have both exhibits. Thank you, Your Honor.
So actually, the first page of exhibit 122 is this cover sheet between from Jackie Holloman to you, Mike. Is that right?
Yes.
And then the second page is the letter that you crafted, right?
It is.
Okay, so let me ask you about this. So you included some facts about each of the claims, which provided the reasons for why you allocate these amounts, right?
Yes.
And at least in this letter, you were taking the assignment from Philadelphia, which is to say, here we have $1 million, and we want you to disperse this as you would recommend. Is that accurate?
Right. She was asking for, given the $1 million and all the plaintiffs plus ND and his mother, how would I recommend allocating it? And this is the product of my thought.
And did you discuss this distribution or allocation with any of the defendants, so OELC or Mr. Olson or Ms. Cornwell?
Not that I recall, no.
Did you ever share with any of the defendants the reasons why you would make certain allocations in certain of the claims?
Not that I recall, no.
And more broadly, for example, with Ms. Cornwell, did you ever discuss some of the evidence that you gathered from her employees that brought into question her own credibility or concerns that others had expressed about her?
Yes.
You did do that?
Yes.
And you remember roughly when you did that?
It would have been earlier on in the case after I'd gotten the investigation file regarding the Tabor allegation.
And did you have the same type of discussion about kind of some of the evidence that would run against OELC with either the defendant OELC or Steve Olson?
Yes.
And when do you remember doing that?
It would have been around the same time frame after I'd gotten the investigation files, and either I or Peter Altman had met with witnesses.
So let's make sure, let's turn it to 124, and we'll make sure before I publish it that we have the right exhibit. You tell us what it is when you get there.
This is my letter to you dated September 19th, 2012 with the allocation.
Again, at least in terms of the settlement amount, let's take SA, for example, on top. You have 500 here, but that's only because Philadelphia Indemnity said make an allocation within the full $1 million or the $1 million that we're offered, right?
Right. It was on the premise that I had to allocate to all of them, and so I did.
Plus ND, who wasn't even a plaintiff.
That was the direction, yes.
All right, and you knew at this time that you were setting this on behalf of Philadelphia Indemnity, that it was unlikely to be a settlement offer that would be accepted by the plaintiffs, right?
That is correct.
In part because it included non-claimants who were involved as part of the settlement, right?
That was a small part of it. The larger part of it was the amount.
And also that no single plaintiff could accept any particular settlement, right?
That was unclear.
So, for example, if Amanda Myrick, for example, wanted to settle her claim, she did not have the ability to because this offer was made as a global offer requirement, right?
And that was unclear.
Did you ever go back and ask for clarification from Philadelphia?
No.
Did you explain this letter of September 19th that you sent out with your clients prior to sending it out?
I don't know if I explained it prior to sending them out, but I did explain it to them.
Okay. But did you have a responsibility under your obligations to OELC and Steve Olson and Rose Hordahl to have apprised them or to have them informed about this before you sent this offer out on September 19th?
I don't know.
So let's turn to that exhibit 125. This is 3 days later on September 21st, 22nd, we have correspondence. Can you explain for us what these are?
This is an email. At bottom, there's an email from Debbie Lowe to you, CCing others, including me. It says, attached, please find correspondence of today's date from Steve Soha. And then I forward that email on to Rose.
I'm sorry.
Oh, I'm sorry.
Slow down, please, when you're reading.
I will.
It says attached, please find correspondence.
It says, attached, please find correspondence of today's date from Steve Soha in the above referenced matter. And I forward that on to Rose Hordahl with an email.
And the last sentence of your email to Ms. Hordahl that this offer is unlikely to be accepted, right?
That is correct.
And so did you have discussions with Ms. Hordahl about what was next, given the fact that this was unlikely to be accepted?
Probably, but I don't recall them.
Right. did you advise her at that point that there have been no depositions taken in preparation for the trial at all?
No, I don't recall that. I do think that this was around the time that we were finalizing the consent judgments.
So prior to the point, whatever that was, the consent judgments were finalized. Did you have discussions with OELC, Steve Olson, and or Rose Fordahl about the fact that the case had not been prepared with expert depositions or lay witness depositions or defense expert opinions prior to trial?
No.
Maybe you turn to exhibit 126.
I see that.
And there's 2 pages to this one.
I'm there.
These are. So the first page is a Steve Olson email to you on September 24th, 2012, right?
Yes.
And it's explained better if we look on page 2 what it's talking about.
Yes.
All right, so explain, just summarize for us what this is all
This is basically Steve Olson asking OALC to pay for Will Ashbow's advice with respect to this matter.
And is it accurate, as Steve Olson has written, that you recommended that he get Will Ashbaugh?
Yes.
And did you recommend Will Ashbaugh because he was a specialist regarding insurance issues?
Yes, insurance coverage issues.
Did you assist Mr. Olson in sending this in to Philadelphia Indemnity?
I believe that he did a first draft and sent it to me, and then I significantly edited or rewrote it.
Let's take a look at exhibit 127 and see if that's it.
So this looks like a draft that Steve Olson sent me to review.
Okay. So I want to look at exhibit 127. Is this, do you have the same cover letter on page 1 as I have up on the screen?
My 127 is no, that in my book is 126.
So let's look at 126. Make sure we're on the right page. So 126 is the document that's got the cover letter that's from Mike Bolosina to Steve Olson. Is that right?
Right. There's a cover email that's up on the screen there.
All right. And then what's the second page of your 126?
My edited version of his letter.
All right. So let's take a look at that. Let me ask you about a couple pieces. Steve Olson with a fairly small 2 paragraphs, and so most of this that we see in exhibit 126 is your writing, right?
Yes.
And you mentioned that you had told Steve Olson that you were going to focus on the complexity of the insurance issues, for one thing, right?
Correct. I don't know if I kept anything that Steve Olson wrote, so this just might be my letter.
All right. Down here in the second really full paragraph, it says, given that I had personal assets to protect, Mr. Bolosina advised that I consult with an attorney who practiced in this area to guide my decision making. And that was your last one, right?
Correct.
As you wrote, again, the coverage issues in this case were complex enough that it took specialized knowledge to assist us in deciding the best course.
Yes.
By the way, did Philadelphia Indemnity reimburse Mr. Olson or any of the other defendants?
For, I do believe that the Olympia Early Learning Center paid Will Ashbow's bill. I don't know that Philadelphia then reimbursed the Olympia Early Learning Center. I don't believe they did.
So let's just take a look at this paragraph I'm highlighting right now that starts, based on Mr. Ashbaugh's advice, I agree to sign a consent judgment with the plaintiffs. This was a paragraph that you wrote for Mr. Olson, right?
Yes.
And does it accurately indicate to the court about how Steve Olson arrived at executing a consent judgment in this case?
As far as I know, yes.
And you were in regular discussions with Mr. Ashbaugh about it? Right?
Yes.
And you point out that Mr. Ashbaugh was instrumental in reviewing and revising the judgment paperwork to ensure that it protected Mr. Olson's interests, right?
That's my understanding, yes.
And that agreeing to the consent judgment stopped the lawsuits against them and ensured that their assets were protected, right?
That is my understanding, yes.
And then as we saw in Exhibit 105, the date that Ms. Hordahl signed off on the consent judgment was October 22, 2012.
Yes, although sitting here today, I have no memory of why that took an extra month. I just don't.
Right. Mr. Bolson, thank you. That's all I have to do.
Thank you. Mr. Lavison or Mr. Rosner, cross-examination.
Thank you. We're gonna have to.
Okay, do you need a minute to do that?
Yes, please.
Okay, let's go off the record, Rick.
Your Honor, may I pull up one of the chairs
Sure.
to store exhibit books on? I think my
Yeah.
tables here is going to even get more crowded.
I think that's a good idea.
I need to get to here, or I feel that people say over there, for not to be in the line of sight, if it's not necessary.
Okay, let's go back on the record, please, Rafe.
First of all, thanks for being here. My name is Jeff Davison. We've never formally met other than waving to each other and speak pleasantries in the hallway. Other than seeing me in the hallway, have you ever spoken with me before?
No.
When's the last time you spoke with a attorney from Soha?
Other than my two depositions, it would have been the fall of 2012.
It would have been the
Fall of 2012, probably September or early October of 2012.
okay, and that's about the time of the settlement.
Yes.
Okay. So I'm a little bit new to the case, and it's been a long time since September when you first testified, so just like to go over a couple of basic things, make sure I understand the stage. So who were your clients that you were representing in the underlying actions?
Olympia Early Learning Center, Steve Olson and Rose Hogdahl.
And what was Rose's role there?
She was I believe, the program director for both of their sites.
Steve Olson?
He was the executive director.
Okay, when the lawsuits were first filed, who were the plaintiffs and who was or were the defendants?
The first defendant was the Olympia Early Learning Center. The first plaintiffs were on behalf of it was Lisa Steele and Doug Thompson, on behalf of Joyce Steele, and I'm blanking on it was Sophie Barbier's mother, and I'm blanking on her name. Those were the first plaintiffs.
Okay, so there were two children and their parents against Olympia Early Learning Center.
Correct.
Okay, and then when did the other lawsuits sort of crop up, if you remember the
I remember the sequence. I don't remember the timing. The next lawsuits were SA, Amanda Myrick and SA, and Nicole Bond and Junior. That was the second lawsuit. The third lawsuit was...
Let me start again. Who was that? Who was the defendant?
That was the Olympia Early Learning Center.
Okay. I'm sorry, can you continue?
And the third lawsuit was basically MM and his mother and JJ and his mother against Olympia Early Learning Center.
Okay, and there's another name in here, ND. Was ND ever a plaintiff?
No, he was not a plaintiff.
Okay. How did ND come into the picture? Why do we see him that child's potential claim in some of the correspondence?
I first learned of ND by reading the police investigation report, and that Eli Tabor had admitted that he had molested him as well at the center. Much later, and there was no claim brought on behalf of him. Much later, Mr. Cochran actually told me that he was representing ND and his mother, and then later he either told me or Mr. Rosner that he wasn't, and so I assumed at that point that maybe they had gotten other plaintiffs' counsel to represent them, but apparently that has never come to fruition.
You're understanding that the ND plaintiffs, the child and the parents, were contacted, solicited for representation, and at some point decided not to hire Mr. Cochran's firm to represent them.
Sustained. Sustained.
What is your understanding of why Mr. Cochran told you that he represented ND? We were in the process of discussing settlement at the time, and one of the issues was, whether ND would be included in the settlement or not, whether anyone was bringing claims on his behalf. And I assume that why he said that yes, at this point he was representing ND and his mother, but then at some point that appeared not to be true anymore. Okay, so talk about the three different lawsuits and the defendant being the Olympic Early Learning Center. Later on, Rose Hogdahl and Steve Olson become defendants.
They do. There are three new lawsuits filed by the three sets of plaintiffs against them as individuals.
Okay. Were those trials going to be part of the first few trials that we heard a little bit about earlier today?
No, they were scheduled for trial in the spring of 2013.
Okay, do you know why they would be separate trials?
Well, they were filed as separate cases. And I don't know. I mean, I never discussed with Mr. Cochran why he filed them as separate cases rather than actually just amending the existing complaints to name them as additional defendants. So I assumed it had to do something with, you know, why we are here today.
Okay. So is it your understanding that all three of those, all three of them became your clients, correct?
Yes.
Olympic Learning Center and Mr. Olson.
Yes.
And so in trying to settle the case, you understand that all three of those clients were covered under one insurance policy, right?
That is my understanding, yes.
You understood that the limit was $1 million.
I understood that that's Philadelphia was taking that position, that its policy limits were $1 million, and they told me that. But I am not an insurance coverage attorney, so I was actually relying upon Will Ashbaugh to advise me whether that was truly the case or not.
Just pause for a second. I keep hearing Olympic. I see. It's Olympia. I just want to make sure.
I'm sorry. I apologize.
Sorry, don't want to record the.
Sure. Every time I said Olympic, I meant to say Olympic. Thank you. So, Mr. Ashbaugh, you contacted him?
I don't recall. I may have contacted him, or I may have had Steve call him, but if I had Steve call him, I would have given him a heads up about what the client might be calling and why.
Okay. Why did your idea to get Mr. Ashbaugh involved?
Yes.
That's because he's a coverage lawyer and you're not. Do I have that right?
Yes. Okay. Also because he's a coverage lawyer, if there were issues to be addressed with Philadelphia, I thought that he would be a more persuasive voice on those issues.
Okay. Did you ever do your own coverage analysis on the policy limit issue?
No. I mean, I looked at the language about policy limits, and that caused me to think that this is probably something that requires specialized knowledge to really understand.
Okay. Did you ever give your three clients advice on what the coverage limits were?
No, I told them what Philadelphia's position was. I told them what the plaintiff's position was, and I also said that Will would be in a better position than me to know whether Philadelphia's position had any merit or not as to what the coverage limits were.
You know whether he did a coverage evaluation or analyzed or evaluated what the policy limits were, that he believed they were.
He told me that legally speaking, that he thought Philadelphia had basically the better side of the argument.
$1 million.
Right. That was the opinion that he shared with me.
Okay. You remember about when he got involved?
It would have been, we saw that email in May of 2012 from Steve about, the divorce issue. It would have been after that.
Okay. And which of these three defendants did he represent?
He technically represented Steve Olson.
But his work proved to the benefit of all three?
Yes.
Okay. And there's another attorney thing out here, Paul Meyer. Who is he?
He was, I believe he was like general counsel to the Olympia Early Learning Center. And that's, and at some point he was brought into the loop as well.
Okay, was he involved he was from Olympia Early Learning Centers counsel all the way through the entire length of the underlying lawsuits.
I believe so. I mean, his existence wasn't brought to my attention until I think I asked John Masterson, do you have an attorney that you work with that could get involved with respect to these coverage issues?
And when it finally came time to consider the covenant judgment settlement scheme, between Mr. Ashbaugh, Mr. Meyer, and yourself, what was the three of your involvements in dealing with the response to the
I don't know what Mr. Meyer's involvement, his involvement was. I know that Will Ashbaugh's involvement was substantial, and I was essentially relying upon him to advise me about whether this was a good thing or not for our clients.
Okay, we'll get to that at some point. I'm still just trying to figure out who's who, and it helps me and who will help it too. Was there a separate lawsuit filed against Mr. Cleaver?
I only learned about that. I was told that there was. I only learned about that after the consent judgments were filed and we moved on to this part of the case.
You learned about that after the consent judgments were filed?
Yes.
Were they filed with the court? You know where they were filed?
The consent judgments? I believe they were filed with the court.
The judgments entered?
Oh. The answer is I believe so, but I don't know. I'm sorry, it's been too long.
Okay. What advice did you give, again, separate from Mr. Ashbaugh, to your three clients about whether or not consider and or accept government judgment offer?
I do recall discussing it with Rose Horgdahl, and after talking through it with Will Ashbaugh and saying, the benefit of this is basically it will stop all the current litigation against you, and there's no risk that you'll be liable for any judgment. So from what Will is saying to me and what I'm seeing myself, this is a good way to go, particularly in light of the fact that these issues about what the policy limits are not going to be resolved anytime soon, and settlement is not going to get done until that issue of policy limits is resolved.
Okay, so at that point in time, the Interpleader action had been filed.
These things were all happening around the same time frames, so I can't say today whether my discussion with Rose Horgdahl occurred before or after the Interpleader action.
Did you give your clients advice whether they should or should not enter into the government judgment settlement?
As to Rose, I gave her advice that she should.
That she should?
Yes.
Okay. You mentioned the benefits. By that point in time, the business had already been shut down because of the fact that Eli Tabor had admitted to the molestation, and that pretty much ruined the business, didn't it?
I know that the business shut down a couple months after the lawsuits were filed. But I did not explore the finances or what had led to it. So I can't answer that question.
Do you have any understanding of why the business shut down a couple months after the confession?
Right. Well, they were running at a loss of about, there was like $25,000 or $30,000 a month. But as to why they were running at a loss, I did not go into that with them.
Do you know whether they lost a number of their clients?
I believe so, and they may have lost some funding sources as well.
Okay. What kind of funding sources? I mean, tell us about that.
I'm sorry. I don't. If I knew then, I don't recall now what their funding sources were.
Okay. Was there a entity, an agency that oversaw the operations at the Learning Center that had to review the operations for purposes of accreditation?
I believe so. And, my current belief is that it would be the Department of Early Learning.
Okay, did they come in and do, is it your understanding they came in and did periodic inspections to continue the accreditation?
I'm sorry, I don't recall to that.
Do you know if they had guidelines that were applicable to the Learning Center?
I believe they did, yes, but I don't recall in any detail about that.
Okay. You know, if they came and checked to make sure that the guidelines were being followed.
Today I can't answer that question.
Okay. I know it's been 10 years, so I appreciate that. Then we have the plaintiffs, and I'd like to just kind of go over just some general stuff about each of the groups of plaintiffs. And the first group is JT, and JT's parents were the Steele, Mrs. Steele and Mr. Johnson, correct?
Yes.
And then the SRB, and that was the Barbie area forum.
Yes.
Okay. These were two girls, correct?
Yes.
And let me back up a minute. Some of the things, this is my first time I've been involved in a case like this. So one of the things you talk about is notice, and one of the things you talk about is disclosures. I kind of like to go through that with you a little bit. When you say in a case there was notice or wasn't notice, what does that mean?
I'm not sure what you're talking about.
Okay. When we talk about notice, my understanding that we're talking about whether or not a learning center, as a defendant or people that work there, had any reason to suspect in advance, had any notice, any reason to suspect that there was a problem.
Okay.
When we talk about disclosures, let me back up. Is that consistent with your understanding of notice?
Yes. I don't know if I typically use that terminology.
Okay,
One of the issues is did they have, to use your terminology, notice that this person, Eli Tabor, would be a danger to children, and that's one thing that you look for in determining whether there's liability for negligence or not.
Okay, and is that specific to each child? So in other words, it could be noticed for some kids and not noticed for other kids.
There's a chronology. So for example, if they have notice in 2010 that Eli Tabor poses a danger for children, that would create liability issues for any abuse that occurred after that notice was received.
Okay. So how about disclosure? Do you know what I mean? What that means?
I think that you mean when a child speaks up and states that they have been molested.
Okay. And in some of these cases, there was, at least for one case that I can think of off the top of my head at the moment, there was one case where there was a disclosure. The child went home and said something to his parents, and then there was an investigation.
In two of the cases, and in the Steele case, it was a 2-year-old that made a comment to her mother, and then in the Barbieri case, it was another 2-year-old that made a comment to her mother that then they then reported, and there was a CPS investigation.
Okay. And those were the JT and SRB, those were the first two victims chronologically that reported.
They were the two first alleged victims chronologically, yes.
And why do you say alleged?
Well, because the CPS investigated and found that the allegation of abuse was not credible.
Okay. Did you think at that point in time that there was going to be potential liability in this case because Eli wasn't fired at that point?
Well, Eli.
Let's nail it down.
Yeah, so at the conclusion of the CPS investigation, was there also a police investigation?
Yes, there was.
Two different investigations. They both came back negative. Okay.
Yes, unfounded.
Okay. So, let me break it down. In your view, did the Learning Center have an obligation not to discharge Eli Taylor, even though the allegations, according to these two investigations, were determined to be unfounded?
Okay. Well, first with the Barbieri allegation that was made against the other Eli Nelson, based on the statements from the mother that she accused and suspected Eli Nelson of abusing her daughter. So that didn't have anything to do with Eli Tabor. The first investigation involved both Eli's because there were two workers named Eli. One of them, she was in Eli Nelson's class, but they actually included Eli Tabor in the investigation as well. So, I mean, this would be my advice to OELC, and they say this accusation was made, it was unfounded. Do we have, should we still fire these people? I would say no, but do realize that you are taking on some extra risk if they are accused later and the allegation does have credibility. So it seems, it strikes me as unfair to fire somebody who has been investigated both by CPS and law enforcement and it was deemed unfounded. But they should know that there is additional risk in keeping these people on.
And I assume you would have argued that what you just said to the jury.
Sure. Yes.
And in your liability analysis, how does the fact that they did not fire Taylor factor into what was happening in front of the jury?
Well, it's
Yeah, we're still talking about the same time frame.
Yes.
Because shortly after these two investigations were completed and it came back that the allegations were unfounded.
If that was the only factor that was being raised, was these allegations were brought in 2009 and Eli Tabor wasn't fired, I would say that we can defend that. But once the SA claim was brought, the earlier allegations were basically just a minor point with respect to liability there. I was more concerned about the red flags that existed, or the notice that existed, to use your terminology, with respect to an inappropriate relationship between SA and Tabor. So I wasn't really thinking like these earlier investigations are a big problem for liability in SA. Instead, my focus was on other things.
Okay. Well, we're gonna get to SA.
Okay.
What I'm trying to do right now is just break this down for the court, so that we just take the 3 sets claims that are going to go to trial. And these two they're both girls.
Correct.
Both females. So, in terms of analyzing liability for these two claims, what other evidence was there that you would have a trial to argue to a jury that there's not enough evidence to support the claim?
Just focusing on the 2 girls.
Yes, just
Well,
focusing on
it was very unusual that the abuse was reported and that CPS and law enforcement stepped in to do an investigation immediately. And as a result of the investigation, there did not appear to be any credible evidence that Eli Tabor had any contact with either of those girls around the time when they made the statement that they had been inappropriately touched. That Eli Nelson, was their teacher and was in the classroom with them during that time frame, but he's a different Eli. So that I thought was, again, it's very rare. Most of these cases, when I was working on them, it would be 20 years ago that the abuse occurred, and reconstructing what happened is very difficult with that time lapse. Because these were investigated immediately, they could talk to the teachers about, what had happened that day. Was Eli Tabor even in the classroom? That kind of thing. And it didn't appear there was credible evidence that Eli Tabor had any contact with him at all.
Okay.
There's also the polygraph where he took a polygraph and he said that he had these 2 male victims and never had any female victims. And that seemed persuasive to me as well.
So Eli Tabor confessed to SA, correct?
Yes.
And there was one other victim that he confessed to. Remember the initials of that person?
Yeah, ND.
Okay. And at that point in time, when he confessed to ND, had ND made a claim? Did anybody even know that ND was on the radar?
No, I think that the Eli Tabor actually revealed that ND was a victim. ND was no longer at the Olympia Early Learning Center, so he wasn't basically interrogated about ND, or ND didn't come up before he mentioned him.
When he was interrogated under a polygraph test about these 2 specific girl, female victims, young victims, what do you have to say?
He wasn't interrogated or asked about the 2 female victims. He was asked a more general question about whether there were other victims than the ones he disclosed, and he answered no, and the polygrapher thought that was credible. But he wasn't asked, did you molest JT? Did you molest SRB? He wasn't asked those specific questions as part of the polygraph.
Okay, was there any evidence that JT or SRB were in contact with, let me break it down. Is there any evidence that JT in contact with Eli Tabor on the day that the alleged incident?
And none that I could see, based on the law enforcement or the CPS investigation.
Okay, and her caregiver there was the other Eli.
Well, at the time the allegations were made.
Sorry.
I'm sorry.
That's all right. Mr. Levinson, I'm having problems with everything you're saying. I would not pick up that mask.
Okay, I'll try it. Part of it's the mask, part of it's I'm from Philadelphia and I'm on it. So I apologize. I lost track.
The question was, her caregiver,
Oh.
JT, was the other Eli.
So JT's teacher or caregiver at the learning center was the other Eli, correct?
All right. At the time that she made the abuse allegations, it was Eli Nelson.
And how about SRB?
All right. At the time that she made the abuse allegations, it was Eli Nelson.
Has there ever been anything that happened with these JT or SRB prior to this incident that would have placed the learning center on notice that Tabor was doing inappropriate things with them?
Not to my knowledge. So the Ms. Steele and or Mr. Thompson, at one point JT was in their class, and they had complained that he was male, he was effeminate, and they thought he was gay, and they did not want him around their daughter. So there was that complaint, and then she was actually moved out of Eli Tabor's class after those complaints were made. So
that happened before the alleged.
Right. That was when, yeah, at least months before. I can't remember precisely, but it was at least months before the alleged abuse.
So the complaint came in and the school moved that child out. Steele Thompson's child.
Right. I think I think they actually shared this complaint with Eli Tabor, and he just said, you know, I'd be more comfortable if you just took her out of my class if they really don't like me. So.
Okay. So are those all points that led you to a conclusion in making your liability, doing an evaluation of liability if the case had gone to trial?
Yes.
I think you testified back in September that you saw these two cases as very weak.
Very weak is, I don't want to be hyperbolic, okay. But yes, I thought that they had issues with both liability and damages.
Okay, what were some of the damage issues for these?
Well, they're 2 years old when the alleged touching occurred, and it's my understanding that 2-year-olds do not have long-term narrative memory, and there's no reason they would have any memory of it, you know, perhaps even days later, of what occurred or what they said. So it's just they're not even interviewed by CPS because you know they're 2 years old, they're barely verbal. So I just don't. I don't want to be cynical, but you know, something bad, something transitory that's bad that happens to you when you're 2 years old, it probably doesn't have any lasting effect.
Okay. Moving on to the next one. Do you recall when those claims or disclosures were made in relationship to the confession?
I to this day, I'm not aware of any disclosures by either JJ or MM of abuse. And the claims came in, they were that was the third set of complaints that were brought. I don't recall ever hearing prior to receiving the complaint on their behalf that they had gone to OELC and made a claim there, or to law enforcement or to CPS.
These were claims made by the parents after they learned of the confession on the essay case?
Yes. Well, I don't know if yes.
And you're saying that the children themselves never made any disclosure at all.
That was my knowledge. And actually I included that question within interrogatories, and in response to the interrogatories, they did not disclose any disclosures, and it might not even be, there might not even be any statements regarding disclosures in their complaint.
Okay. Other than the fact that the kids were at the daycare at the same time that Eli Tabor was there, after the parents found out that Eli Tabor, they confessed to the SA abuse. Was there any other evidence that they had other than the opportunity evidence, just being in the same school at the same time that Tabor was there? Was there anything else that you can recall that supported the parents' claims of abuse?
Yes, with I believe one of the employees, after Eli Tabor was arrested, told MM's mother that Eli Tabor had escorted MM to the bathroom. And with JJ, I believe that somebody told JJ's mother that Eli Tabor had taken JJ to a doctor's appointment, had driven him to a doctor's appointment.
Okay. Somebody asked him to take it to a doctor's appointment?
I don't remember the details.
All right. So those are two other opportunity issues, correct?
Right.
Could almost anybody at that school have done the same thing, made an opportunity claim?
Yes. I mean, the thing is that I think that those claims were based on, there was an opportunity for him to molest him, and there were some behavioral issues that they observed, and so yeah, there could be a lot of people coming forward with that type of claim.
Okay. Well, there was some evidence that JJ was in therapy. Was he in therapy before and after?
I'm sorry.
Well, there was no alleged incident specifically.
Not that I'm aware of.
Just that he happened to be there.
And the answer to your question is I just don't recall that level of detail about his claim.
So in terms of evaluating liability, how did you see these two things?
Well, without disclosures and based on behavioral characteristics and this opportunity, and I thought that those cases had issues with respect to liability, and therefore damages, and also again based on the polygraph, where Eli Tabor basically said that I have these two victims from the OELC and not any others.
How much weight do you think the jury would put on the fact that Tabor admitted to SA? Of course, he was caught in the act of SA.
He was.
And admitted to somebody that he didn't have to admit to, and B, how would that play to a jury in your mind in terms of the credibility of him saying, these are my own people?
Yeah, I consider that persuasive, but when you're asking me to predict how a jury would view that evidence, it's very difficult. I think that different jurors would view it differently.
And you can't guarantee your clients how a jury is going to decide any more than I can, correct?
That is very correct.
So every case has a settlement value.
Yes, particularly today.
Okay. And you did make recommendations on settlement value at some point, which we'll get to later.
Yes.
And then the last two I have here. Let me just back up. Did either, with respect to JJ and anybody, did either of the parents ever report anything to the police or the department?
Oh, sorry.
Children early learning or CPS or any complaints at all by anybody to any agency?
Not to my knowledge.
Okay. Okay, moving on to 8K, I'm sorry. Yeah, 8K and SA. So SA is the one case where you actually thought that there could be some significant liability, right?
Yes.
So if you could kind of describe the history of Eli Tabor and SA from the time Eli started working at the Learning Center and to the time he got caught in the house.
SA started there as before kindergarten, and at some point, Eli was his teacher. At some point in the fall of 2010, his mother actually invited him to come live with them.
Invited Tabor
to come live with them so that he could provide essentially childcare in exchange for free rent. And he did that. And according to Eli Tabor and SA, when he was alone with him in the house, he began to sexually abuse him. And this went on for a number of months so I think it may have been like September or October of 2010. In January of 2011, Ms. Myrick came home and saw them on the couch in a position that made her very concerned, and that's when he basically admitted that something was going on. She then reported it to OELC. Then she reported it to law enforcement, and they did an investigation.
Okay, what did Tabor do the day he was caught?
I think he came to OELC and resigned, but did not say the reason why. He just said that he was moving back into with his father in Shelton.
Okay, and mother also called. Listen, Big Dog.
Horgdahl.
I'm sorry?
Horgdahl.
Horgdahl. And this is Horgdahl. What she do?
She actually called a professional at the Department of Early Learning and asked for advice about what to do next. And then a couple days later, that she got a call back, and then the advice was that she needed to call CPS.
And did she call CPS?
She did.
Did she actually get a violation for not calling CPS right away?
She did. There's a legal obligation that you have to call CPS or law enforcement within 48 hours.
Okay. It took her next day.
Right. She waited to hear back from DEL and got that advice from them to call CPS, and that's when she did.
Okay. Now, what were your views on liability for Olympic Early Learning Center for claims by SA given your understanding that the offenses happened in the home and not at the learning.
I did not think that that would insulate Olympia Early Learning Center from liability.
More than that.
Just there are cases that do not, create a defense if the mechanism by which they became introduced was, at the defendant's location. So that's a point that could be raised and argued to the jury, but it would not be a point on summary judgment. And I did not think that it would be persuasive to most jurors to exonerate Olympia Early Learning Center from liability.
Okay. You were asked earlier today about the Tigman Rollins cases.
Technically, yes.
Was it part of your planning to, I think you already testified in September, you were just planning to admit liability with respect to myself.
That's what I was going to recommend, is that we admit liability.
Okay, why are we going to make that recommendation?
Because I thought that bringing in all the evidence about red flags would, risk inflaming the jury that these red flags were not attended to or adhered to. So I thought as a defense strategy, it might be better just to admit liability and then put the focus on SA and his mother and damages.
Okay. How would the Tigman Rollins factors play into your analysis of liability at the end of the day? Would there be any allocation?
Well,
would you be asking the jury for an allocation based on Tigman Rollins? Yeah?
This is my understanding of the law at that time, and I've not done a practice in this area for like 7 years or so. So I don't know if there have been developments since then. My understanding at the time is if the intentional tortfeasor is actually named in the lawsuit, then the jury can allocate between the intentional tortfeasor and the negligent tortfeasors. But if the intentional tortfeasor is not named as a defendant in the lawsuit, you can argue about proximate cause, that this was proximately caused by him. Oops, sorry, him, not us, but that you don't get that same kind of allocation on the jury verdict form. And I can remember when that decision coming out, hosting a panel discussion with Judge Downing and some others to discuss, Tigman and allocation. Now, has that changed in the last 7 years or so? I don't know, but that was my understanding of the law at the time.
Okay, so what kind of jury instruction do you think we would have gotten on the allocation issue in your case, trial where Eli is not named as a defendant?
Right. Well, you can.
Are we talking about the admitted SA liability case? Or one of the other cases?
We're talking about SA now?
You could attempt to allocate fault to other parties, such as the mother, although the burden in order to do that is rather high, both legally and factually.
I'm sorry, the last part you mentioned.
Factually, that it's tricky for the defense attorney to argue that the real party at fault here is the mother, not OELC.
Did you argue that the real party at fault was favored?
You can, but again, you don't. In my understanding of Tigman is unless he's a defendant in the lawsuit, then you can't. Then you can't do that. You can't seek a specific allocation for an intentional tortfeasor who's not a defendant in the lawsuit.
And that's why Eli Gator was sued in a separate lawsuit.
That would be speculation, but I think that they sued him in a separate lawsuit without telling me, so that they could do discovery in that lawsuit without me knowing it was happening.
And what makes you say that?
That's just when I found out about it. I just thought, why would they do that? and it's just like I don't. The thing is that I don't think they were doing it to avoid Tegman by just not naming him as an individual defendant. They would avoid Tegman. But you know, and then I thought when I saw that the report from the psychologist Mark Logan, because I was wondering how did they get into the jail to do this evaluation of Eli Tabor without me ever knowing it occurred? And the answer probably is they did that in connection with this lawsuit that I didn't know about. So, but this is all speculation because I didn't know about this lawsuit until after these matters, the consent judgments were entered, and I've never spoken to Mr. Cochran about why he did it.
Did you eventually get a copy of that investigative report?
From Mr. Logan, I got a copy of his expert report, yes.
I'm sorry. I was behind too much.
Question, did you ever get a copy of that investigation?
I got a copy of Dr. Logan's his expert report.
Okay, he went to interview Tabor while he was in jail.
Right, and apparently do some psychological testing of him as well.
Okay, was that something that the plaintiff disclosed to you?
Yes,
before the settlement?
Mr. Cochran, I think in May of 2012, just sent me his expert report.
Okay, that was a book.
Yes.
Remember when it was in relationship to the settlement?
It would have been before.
A week before?
No, it would have been months before.
Months before?
I may be wrong. I know it's an exhibit, but I thought it was May of 2012 when I received it.
Okay. That's something that you understand he was planning to use in the trial.
Yes.
Okay. So we'll take a look at it this afternoon when we come back, but I'm going to ask you some questions now. Just waste some time.
Let's break. 11:52. Let's come back at 1:30.
Okay.
Thank you. It's in recess till 1:30.
All right.
Just for later time?
Yes.
Do you want daily copy as well then?
Yes.
Okay.
Hi, this is Steve. And we're looking for those law that confuse the judges of the witness. And then just leave it as it is, or leave it It's like the regular individual.
I thought of it and I'm like, nah. Yeah.
Okay, so what do I do? Yes. More, okay. And stop live stream.